Mr. Sullivan's correct in a lot of the things he said here this morning. But first, I think that it's necessary that, the defendant, on behalf of the defendant, we thank you for sitting through this trial. It's not easy. Granted, it went a lot quicker than we thought it would be, but still it's difficult to be away from your homes and your families and your employment to come in here to have to sit through this. And so we do really appreciate that. I've indicated before that there's no machine that can play your role, and so your role here is indispensable. And that being said, I've never been called a magician before, but I have been called the fastest talking lawyer in Rock County, so I'll try to keep it slow for you. We saw that videotape again this morning. Does that videotape illustrate the actions of a man who's arming himself? In the videotape, Mr. Jakubowski is seen grabbing the first rifles he can find behind the counter. He grabs them, he sticks them in his bag. He doesn't look at them. He just grabs the first ones he can find, stuffs them in the bag. Then, if you recall, and by the way, there's been no evidence in this trial that the defendant knew that that automatic weapon was an automatic weapon. He just grabbed the first guns he could find. I think he looked like a kid in a candy store in this video. After he takes the guns from the wall, he turns around and scoops up as many handguns as he can. So many that they're falling out of the bag. He doesn't look to see what calibers they are, what brands they are, anything. He just takes them all, sticks them in the bag. The same thing is true with the ammunition. Turns around, starts grabbing boxes of ammunition without looking to see if they'll fit any specific rifle, pistol, or the caliber, or anything like that. Just grabbing ammo as much as he can fit in the bag. Fills up the bag. Same with the parts in the magazines. He doesn't look at them specifically to say, gee, this magazine will fit into that fully automatic weapon, or this Glock magazine will fit into that pistol. He just puts them all in there. And the reason that's important, folks, is the very same conduct that the state is relying upon to show that the defendant stole these firearms, they're relying upon to say that he armed himself. Now, you'll see in the law this happens often. You'll see oftentimes somebody's charged with both operating while intoxicated, perhaps, and reckless driving out of the same conduct. So clearly, the law provides that this type of thing can happen, but it doesn't have to happen this way. There are jury instructions that determine or that define what arming is. But there are also jury instructions that ask you to rely on your common sense. Mr. Sullivan indicated earlier that he's a lawyer, and lawyers sometimes parse out words like what does is mean, that slick Willie line. I want you to tell me what you think the definition of armed is. Is armed defined as equipping oneself with weaponry? Or is it preparing oneself for warfare or combat? Or is it simply equipping yourself with what is needed for effective action? And that could be a shovel, a dictionary, or arm yourself with knowledge. Mr. Jakubowski never loaded any of those firearms. He never placed one of them on his person. He showed up there with a bag, not a holster. If you're going to arm yourself, you're going to bring a holster to put your gun in it. Or you're going to load the gun and put it on yourself. You're just not going to stuff it in a bag and carry it away. The state of Wisconsin, through the legislature, might say that that is arming oneself, but you're not the legislature. But today you are the judge. And you can use your common sense to tell us whether that is arming oneself or that is simply theft. Is that a person who's just stealing as many things as he can, or is that a man who's in there arming himself because he's preparing himself for combat? Well, if he's doing that, he did a pretty crappy job because he didn't load the guns. He didn't even know what the ammunition met or matched the guns. In each one of the offenses charged, the state has to show that there's intent. Burglary, they have to show that the intent to steal, as this document was charged, not intent to commit a felony therein, the enclosure, intent to steal has to be established and it has to be formed prior to entering the building. Well, bless you. I agree with Mr. Sullivan. The fact that Mr. Jakubowski walked up to the building with a big bag in his hand, it does establish intent to steal. The fact that Mr. Jakubowski had a hammer with him when he went to the building shows that he intended to break into the building with the intent to steal. And so we really have no qualms about this allegation that Mr. Jakubowski burglarized this building and that he used a hammer to do so and that he stole a bunch of guns. For God's sake, he admitted it on a number of occasions. He's never denied it. Our qualm is with the fact that the state is saying that he armed himself. And that harkens back to the stuff we saw in the newspaper, that Mr. Jakubowski was a threat to society and that he was going to shoot up a school or something like that. We have no evidence that even shows Mr. Jakubowski knew he had an automatic weapon in his possession. And if he did, he certainly didn't have the ammunition to fit it. All of those guns, save for two, were inoperable because they didn't have the proper ammunition. Yeah, it could be said that a gun, an unloaded gun, is still a dangerous weapon. Well, it is. You could hit somebody with it, just like you could with that hammer. But I think the common sense meaning that we can all ascribe to what that dangerous weapon means is a weapon that's loaded. That's a dangerous weapon.
Your Honor, I'm going to have to object to this point in time. This is asking the jury to disobey their oath and not follow the law. It's defined in the law.
Your jury will follow the law, and obviously you can't argue nullification, Mr. Murphy.
I'm not trying to, Judge.
Move on.
Mr. Sullivan will get another chance to make a statement about this because he has the burden of proof. He can come up and make a separate argument. At that time, Mr. Sullivan can say that I'm asking the jury to violate their oath and to not follow the law. And I'm assuming he will. But the fact remains that you are to rely on your common sense. There's a definition for armed in the statute. And that definition carries with it an intent requirement. And I believe it says that, and this is in the instruction for arming oneself with a dangerous weapon. Armed means the defendant knowingly took control of a dangerous weapon. That means he knows it's a dangerous weapon at that point. You have to prove that Mr. Jakubowski knew that that was a dangerous weapon, that he knew that an unarmed or an unloaded weapon, an inoperable weapon, is a dangerous weapon. A dangerous weapon is defined as an item that can inflict death or great bodily injury. Anything in that store, including the hammer, could have done that, or the stool. Again, use your common sense. Was that a man who was arming himself in that enclosure? Is that a man who was just stealing as many things as he can find, like he's in a candy store, and leaving? At the beginning of this trial, and in fact the court instructed you that if you can reconcile the evidence on a reasonable hypothesis that results in the defendant's innocence, you're to do so. The court said you're to follow the law. I submit to you a reasonable hypothesis is that that conduct was not conduct in arming oneself, but conduct in stealing things. Mr. Jakubowski is a thief, not a terrorist. I'm sure you'll follow the law as the court instructs you to do, and I think you'll find that a reasonable hypothesis can be found that shows that Mr. Jakubowski wasn't arming himself. You're required to do so, and I ask you to do so. Thank you.